Good afternoon. My name is James Chojari, and I'm the Executive Director at Legal Assistance for Seniors. It is my honor to welcome you to today's program, Working with Caregivers, Solutions to Common Problems, presented by Robert Nuttleman and Hina Shah. This is the first in our series of 4 webinars addressing various topics on elder abuse. As you all probably know, when we hold the conference in person, it takes many dedicated people and agencies coming together to produce such a large function. And this webinar series is no different. First, I would like to thank all of our sponsors who continue to support the conference in the webinar format. Their continued dedication and excitement for the work we do is critical to the success of the conference, and we offer our deepest gratitude. In particular, I'd like to thank our top 4 sponsors: Michael Stevens, Probate and Trust Realtor, our Diamond sponsor; Campbell Green, our Platinum sponsor; and our 2 Gold sponsors, the Tile Shop and Acuna Regularly. Michael Stevens has been an incredible support to LAS and is always there to help with a great enthusiasm. If it involves supporting older adults, Michael is always there with a big yes, and how can I help? In addition to a high level of professionalism, Michael and his team at Highland Partners Real Estate bring much empathy and compassion to the many probate and trust sales they handle. Michael approaches each transaction, whether for his customers or working with conservators, attorneys, or other fiduciaries, with real understanding. Thanks to Highland Partners and Michael for your steadfast support of LAS over the years. Philip Campbell has been with LAS long before I came on board. For anything big or small, Phil is always helping LAS. From Campbell Green themed M&Ms to guiding the agency by volunteering to be the board president, Phil believes in older adults in LAS. Campbell Green is another of our longtime benefactors. Many of you know their legal practice in estate planning, probate and trust administration, and conservatorship and elder protection. But we here at LAS know Phil and his team as great friends and champions of the rights of older adults. Thank you, Phil and Campbell Green, for always being there. The Tile Shop, with their showroom in neighboring Berkeley, and Acuna Regularly with business in estate planning, probate and trust administration, and conservatorship and special need trusts, are our 2 Gold sponsors and have been supporting LAS's work around preventing elder abuse for many years. They are always there to support this work, and we really do appreciate that they continue to believe in the work we do. Thank you again to Tile Shop and Acuna Regularly. We have a whole host of sponsors at the silver and bronze levels that we are also incredibly grateful for. Many of these sponsors, like our Diamond, Platinum, and Gold sponsors, have been supporting this work for many years. They are our collaborators and partners and keep us excited to continue to do this work. At the silver level, we have Anderson, Yadzi, Wang, Minton, and Horn, Fiduciary Accounting Services, Holland and Knight, and the Professional Fiduciary Association of California, or PFAC. At the bronze level, we have 21st Century Care Solutions, ARM Homes, Evans Law Firm, Golden Gate Fiduciary Services, IMT Associates, the Law Offices of Sonoy Rousseau, and the Law Offices of Phillips & Phillips and Lifelong Medical. We really appreciate all of our sponsors at the silver and bronze levels. And a special thanks go out to Office Information Systems and Supervisor Wilma Chan for their support of the conference. In addition, Golden Gate University has continued to support LAS in this webinar series with technical support and serving as an honorary event host. The Institute on Aging and their amazing staff continue to be wonderful partners in providing continuing education units for a wide variety of professionals. Last but not least is the team that has contributed their time and hard work over the past several months to transition this in-person conference to an online experience. Greg Bedard, Jenny Pardini, and the entire LAS staff. We truly appreciate all the work they have done. For those of you who have been coming to the conference regularly over the years, you might notice that there is a familiar name missing from that thank you list. LAS lost our colleague and dear friend, Katie Brady, earlier this year. Her bright smile and positive energy will be sorely missed at the conference and throughout the year at the many events that she would attend. Katie was a champion for older adults, a thoughtful and caring coworker, and an avid softball player. Katie brightened any room she walked into, and as Katie used to say, go team go. Now, for some housekeeping, before we get started with today's program, we have a wonderful educational presentation followed by a live Q&A. If you have a question, please submit it through the Q&A icon at the bottom of your screen. Staff will be monitoring these questions for the moderator. We will try to get to all of your questions, but if we're unable to answer everything during the session, we will do our best to follow up with you after the presentation. For those of you who need continuing education units, you will receive a post-event email within a day or two of this session with steps on redeeming your credit. Lastly, we welcome your feedback to help us improve your experience and continue to offer high quality education through a post-event survey. As I'm sure you're aware, today's presentation is part of a series of 4 webinars LAS is producing in the coming weeks. They are all free of charge and open to the public, though a donation of $25 per webinar will be gratefully appreciated and accepted in order to support our ongoing work. We hope you find these presentations informative and useful. You can register for these webinars by visiting our website at lashighcap.org. That's LASHICAP.org, and going to the events page. Thank you again for joining us, and I hope you enjoy the program.
Good afternoon. My name is Jenny Pardini, and I am the Community Education Coordinator with Legal Assistance for Seniors. I'm delighted to be your moderator for this webinar. Today, you'll hear a 1-hour educational presentation from our guest speakers, followed by a Q&A that I will be moderating. If you have any questions for our speakers, please submit them at any point during the program by clicking on the Q&A icon at the bottom of the meeting screen. If you have any technical issues, you can ask us in the chat and our technical team will do their best to assist you. If you would like to use the closed caption feature, click on the live transcript button at the bottom of the meeting screen and choose Show Subtitle. It is my pleasure to introduce you to today's speakers, Hina Shah and Robert Nettleman. Hina Shah is a professor of law and director of the Women's Employment Rights Clinic work at Golden Gate University School of Law. Work advocates for the rights of low-income and immigrant workers through direct service, impact litigation, and public policy work, and in coordination with community-based organizations. Work serves as legal counsel to the California Domestic Workers Coalition, helping expand and enforce workplace protections for domestic workers. Professor Shah has lectured and written on the plight of low-wage and immigrant workers. Prior to joining GGU Law, Professor Shah worked for over a decade as an employment litigator for a private union-side law firms and nonprofit organizations, and has substantial appellate experience as a staff attorney at the Ninth Circuit. She currently serves on the executive committee of the Labor and Employment Law section of the California Lawyers Association. Robert Nettleman is the owner and primary attorney at Nettleman Law Firm PC. He represents individuals and companies in federal and state court and various administrative agencies, such as the California Department of Industrial Relations, the Equal Employment Opportunity Commission, the Department of Fair Employment and Housing, and the Unemployment Insurance Appeals Board. A significant focus of Mr. Nettleman's practice relates to wage and hour claims, breach of contract, trade secret protection, claims of sex, race, and age and pregnancy discrimination, and or harassment and accommodating persons with disabilities. Mr. Nettleman advises and represents business clients in employment and business matters in an attempt to avoid litigation and reduce potential exposure to claims of all kinds in light of developing law. A particular focus of Mr. Nettleman's practice includes advising caregiver agencies, trustees, conservators, families, residential care facilities, care homes, and others regarding wage and hour and employment laws in the elder care industry. Rob and Hina, welcome to the program.
Thank you so much, Jennifer. It's a pleasure to be here. I'm going to go ahead and attempt to share my screen if I can do this correctly. So thank you, everybody, for the opportunity to work together. I'm so excited to be presenting with Hina. She and I know have been looking forward to this for some time. I have tremendous respect for Hina and everything she does and everything the Workers and Employment Rights Clinic does, as well as LAS. So again, it truly is an honor to be here. Let's kind of jump right into it and just kind of jump at the beginning. So we're talking about caregivers. And one of the first questions that I think we need to answer is, well, who's the employer and why does it even matter in the first place? Well, it's going to matter because a clever plaintiff's attorney is going to add whoever they can. If they're smart, they're going to add as many different defendants if they can if there's a problem. But even more importantly, before we get to what the potential liabilities are, is we want to make sure we're doing things correctly. And to do things correctly, we have to have that kind of understanding. So jumping in our Wayback Machine, we're going way back to the Borrello case, which has seen some renewed discussion. And prior to COVID, it was a big issue that was coming up, because that was the standard test, or at least people assumed it was the standard test for a long period of time. It actually was a test that was developed having to do with whether or not somebody was a worker, an employer under the workers' compensation system. But it was determined kind of that was generally applicable, or people thought it was generally applicable for a lot of different wage and hour purposes and employment law purposes. And the primary issue that Borrello was looking at is who has the right to control. And it's not just whether or not they do control, it's whether or not you have the right to control. So for example, if I can control how you're going to do the work, I'm telling you when to show up to work, I'm telling you how to do the work, I have that control. Although that is the primary factor, Borrello had, I think, 11 other factors that would generally look at different things, like, does this person, who provides the tools, are taxes withheld, are they paid by the piece, or are they paid by the hour, or are they paid by a salary? A number of different factors. No one factor was necessarily determinative. And so it did have its problems. It had its problems because I could look at a case and say, oh, well, this person is clearly an independent contractor. And you could look at the case and say, no, this person is an employee. And in fact, you could have different agencies coming to different decisions, because companies like the Employment Development Department or the IRS, they each had their own tests. The IRS, I think, has a 22-factor test, and the EDD used to have a test where if you answered yes to the first 3 questions, then they're an employee. If you answer no to the next 3 questions, then they're more likely an employee. And then there's 4 others that kind of throw in there. But a lot of those different factors are really just different ways of looking at these, what we call the Borrello factors, to look into whether or not somebody is or is not an employee. And for whatever reason, a lot of these cases tend to come out of the agricultural area. And so I believe Borrello was a case, I forget what they were, what the planners were. It was actually kind of an interesting case, because you don't know this unless you know, it wasn't said it in the case, but if you know anything about Borrello and stuff, Borrello was a company that did farming and would hire workers and would pay them as employees. And then one year Borrello decided, you know, I'm not going to do it anymore. I'm not going to plant the fields this year. And the workers came to him and said, look, we still want to generate our income, so we'll take care of things, and we'll take care of doing the planting, we'll take care of doing all the field work and everything that has to go into getting the produce out to the purchasers. And I think it was a workers' comp investigator was asking for information and found out that these people were not listed as employees for Borrello, and they issued Borrello a citation, and he appealed it, and they went off from there. Ultimately, again, these multi-factors came out, and the court ended up saying that Borrello was the employer, because they looked at not just whether or not these employees in this year were providing their own tools or not. And in fact, the reality was they were getting a lot of the tools from the employer. And the Borrello still retained the right to control things because it was his land and he could decide who came and went. And so there was sufficient control. And as I said, there's pretty much the assumption that this is who is or isn't the employer for a lot of employment reasons until 2010. In 2010, was another agricultural case, the Martinez v. Combs case, where I believe it was strawberries. The farmer hired employees to pick strawberries, and he would sell them to different producers who would then sell them to the different stores. And occasionally the producers would come out maybe about once a week or so and just kind of oversee things, make sure people were packing things correctly, that they weren't picking the strawberries that were not ripe yet, or the ones that had been destroyed, and how to present them into the box. Well, eventually, as sometimes happens, unfortunately, the owner of the fields, Martinez, I think was the plaintiff, the owner of the farmer wasn't able to pay his employees, and he filed bankruptcy. And so the employees sued not only the farmer, but also the producers, arguing that, hey, these producers are really our employees, partly arguing under Borrello because they were controlling it. But more importantly, they were arguing that under the wage order, these producers would be considered employees. Because the wage order, first of all, what is a wage order? Every business, every company that has employees, one of 17 different wage orders applies to them. Some are, there's some for agricultural, there's some for places that provide food and board and housing. There's some that for households around the works, there's manufacturing, so a number of different ones. And the labor code doesn't have a single definition of who is or is not an employer. The wage order does, and in this case, I think it was wage order 9. Wait, no, now I'm getting confused. I can't remember. One of the ways, there's one for agriculture, and it has the same definition that all the other wage order has about who is an employer. An employer is anyone who engages somebody to work, or who suffers or permits the person to work, or who exercises control over the wages, hours, or working conditions. And the plaintiffs were arguing this definition of employer is what should apply, because that's what's in the wage order, and the wage order defines when somebody gets paid and how they're supposed to get paid. And ultimately, the California Supreme Court adopted that argument, saying yes, and you're the employer if you meet any of those three: to engage the work, which is your Borrello test, suffer or permit, which we're going to get to shortly, or that you exercise control over the wages, hours, or working conditions. And when you think about that, it's a very broad test as to who is or isn't an employer. A couple of years later, in the Guerrero case, so as an example of how broad that is, that was a case where a worker was hired to provide services through IHSS, the in-home support services. For those of you who aren't familiar, IHSS is a state program administered by the county that allows people who with insufficient income to receive home care for a variety of services from people. They typically don't pay a lot of money, but it is a way that can get people services that otherwise might not be able to afford it. This particular worker worked for about 3 months and didn't get paid. So she sued the person she was providing the care to. She sued the person that hired her. She sued the county of Sonoma, who administered IHSS, and sued the state of California. The county filed a demur. They said, even if everything you say is true, we're not the employer because we didn't exercise any control of the hours, wages, or working conditions. We didn't decide who to hire. It wasn't our decision. All we do is monitor things. And the court went through a pretty good analysis, a detailed analysis of the history, looking at Martinez v. Combs, and ultimately decided that the county, because the county has certain requirements, the county has to make sure that the work is actually being performed. They can't just write checks. They have to make sure that the work is being performed. They also have obligations to do periodic checks to make sure, some wellness checks, et cetera. And ultimately, the county holds the purse strings. Although the state funds it, the money goes to the county, and the county has to dole that money out. And if the county says, we're not going to pay, well, that is in effect exercising control over the wages. Also, IHSS determines how many hours the people are going to work and what type of work they're supposed to be doing. So the court didn't have much issue in finding that the county was exercising control of the hours, wages, or working conditions. As I mentioned, I do a lot of work with trustees and other professional fiduciaries and conservators. So you want to consider in your job as a trustee or conservator, are you exercising that control? Are you that gatekeeper holding the purse strings that's determining whether or not something is going to get paid? Somebody's going to get paid. Are you telling the caregiver what type of work to do? Are you directing when they're going to come into work? The more you exercise that kind of control, the greater the chance of you being sued individually. And we'll be talking a little bit later on about some different ways to limit those potential liabilities. The primary one is we do things right from the beginning. And then in 2018, we had another huge change, which is the Dynamics case. Many people are familiar with this. The Dynamics case, in my opinion, pretty much eliminated independent contractors in California for a lot of people. What it did is in this case, it was about truck drivers, and the question was whether or not the truck drivers were employees or not. Because these were independent people, oftentimes they have their own trucks, they work for multiple different places. They were subject to some amount of control, but not a whole lot of control. And the California Supreme Court looked at that suffer or permit section from Martinez and said, well, we don't really have a definition of what a suffer or permit mean. So for example, if I say, you come to my house and say, hey, Rob, I noticed your lawn's looking a little big. I'm going to go ahead and mow that for you. I don't say anything, but I sit out there drinking my mint julep as I, and want to do it occasionally, watching you mow my lawn. Have I just suffered or permitted you to work? Well, maybe. Well, the California Supreme Court wasn't satisfied with not having a good definition of what does that suffer or permit mean. So they came up with their own definition. And how else would they come up with the definition? They do what every court should do. You look to the jurisdiction of a state over, across the world, over in Massachusetts. And they said, hey, what is the test they have? And the test they came up with is a 3-part test. And the hirer, if I want you to be an independent contractor, I have to prove all 3 things: that you're free from control and direction, that you're performing work that's outside the normal scope of my business, and that you are customarily engaged in independent trade, occupation, or business. Now, mind you, these are all factors we knew from before. Borrello already told us that free from control and direction is the primary. Whether or not the person is performing work outside of the usual course of the employment of the hiring entity's business was always a factor, just was not a determining factor, as was whether the person was customarily engaged in their own independent trade, occupation, and business. What made Dynamics unique was the employer, the hiring entity, has to prove all 3 of these. If the employer doesn't prove all 3 of them, then that person is going to be considered an employee. Originally under Dynamics, it was saying at least for wage and hour issues under the wage order, it left open questions about whether or not labor code claims like unpaid expenses or others would have that same definition. The legislature in 2020 answered that question for us by passing AB 5, which adopted the ABC test as the deciding factor. That is the test that is used for any claims under the labor code, as well as from the EDD for unemployment insurance purposes. So they kind of got rid of the old EDD test and they use this Dynamics test. Now, as I rail on Dynamics, I'm not a fan of the decision. I'm not a fan of AB 5. I make no bones about that. The good thing about it is a definitive test. Borrello was wishy-washy. You could have different decisions. Rightly or wrongly, Dynamics gives a very hard and fast rule. It's a very bright line rule that's very easy to follow. AB 5 kind of modified a little bit because they did put in some exceptions, some very good exceptions, some necessary exceptions, and it got cleaned up a little bit later on in 2020 with AB 2237 or 57. I get the numbers mixed up. So we do have some very definitive tests that we can use for it. It's just a harder test. In 2019, the courts had to ask, there was a question, is Duffy versus something, a Hart, I can't remember, maybe you remember, but in that case, the question was whether or not the Domestic Workers Bill of Rights is supposed to use the Dynamics test, this 3-part test. The Domestic Workers Bill of Rights was a legislation that was passed in 2014 to try and curb the abuses that was happening in the elder care industry. A lot of people were hired under the table. They were hired as independent contractor. They weren't given, prior to 2014 in California, many caregivers were not even entitled to overtime. And one of the primary things the Domestic Workers Bill of Rights did is it requires personal attendants or caregivers to get overtime. In that, they have their own definition of who is a domestic work employer and who's a domestic work employee. And in the Duffy case, the court decided because the Domestic Workers Bill of Rights has its own definition of domestic work employer that does not include that suffer or permit language, then dynamics does not apply. It still has the definition of whether or not you control the hours, wages, or working conditions. So it still is very broad. And it also still continues that engage to work, which is the Barolo test, but it doesn't include the ABC test. So when you're hiring somebody at home, you are still looking at primarily at that, whether or not you control over the hours, wages, or working conditions, and to what extent are you controlling what they're doing. Hina, I'm going to turn it over to you to talk a little bit about some of the basic caregiver laws.
Yeah, if I can just add, thank you so much, Rob, for that kind of broad overview. I just want to make a couple of takeaways from kind of Rob's presentation, which is that generally most domestic service employees are not going to be independent contractors. They're going to be able to meet any of those tests, at least from the worker's perspective. There's sufficient basis to treat them as employees. And also be aware whether you are directly hiring someone or not, you can still be considered a joint employer based on the tests that Rob talked about, because they are incredibly broad. And finally, if you're hiring through a home health agency, exercise some due diligence, because some home health agencies are considered, they're not considered the employer if they are just a referral agency. And so there are all kinds of requirements under the civil code about when an agency is just treated as a referral agency. That's like a kind of a dating app for employers and employees. So be careful that you do some due diligence to find out whether the agency that you're working with, who's providing you caregivers, is really going to be treated as the employer, at least to shield some of your own liability if you go that route. As Rob said, there are a complex patchwork of state and federal laws and regulations that govern wage and working conditions in California. And it is even more complicated in the caregiver space. What laws applies are going to be subject to where the work is performed and what the work is. Employers must comply with the law that provides the greatest protection in California. And so it's going to be important to take a look at both the federal, state, and whether in the county or municipality that the work is being performed, whether there is some special rules or ordinances that govern wage and hour. To start first with who is doing what matters. Domestic workers are, they include nannies, childcare providers, caregivers or attendants to people with disabilities or to older adults. They also include house cleaners, day laborers, gardeners. There's a whole lot of folks who are within the domestic worker terminology. The important thing is that when we use the term domestic workers, we're really focusing on the work that is performed in a private home, whether they're directly hired by the household or a family member that's doing the direct hire, or by an agency. Under state law, a domestic worker who spends 80% or more of their time providing care services, so activities of daily living or instrumental activities, things like bathing, transferring, grooming. If they spend 80% or more of their time on those care activities for children, people with disabilities, or older adults, and they spend 20% or less doing housekeeping work, they're going to be considered personal attendants. And different state overtime rules apply to personal attendants, and they're not subject to many of the wage and hour requirements under the wage order that Rob was talking about. So you want to I'm not going to go into all of the different nuances of all of the overtime laws because there's a lot, but it's a flag. If someone is really strictly hired as a caregiver and they're spending most of their time providing care, they're going to be considered personal attendants, and there are different rules that apply to them. Under federal law, there's different terminology. And a person who provides mostly fellowship and protection to seniors is going to be called a companion. The majority of the time, the worker is there for conversation, reading, accompanying the person on walks or errands, taking them to appointments. And 20% or less of their time is focused on care activities and housekeeping. Those workers are companions under federal law, and they are exempt from federal overtime law if they are directly hired by the household, but they may be subject to state law. So in some of these overtime laws, for example, for personal attendants, there are lots of exemptions that are written within that law. So they may be exempt from some state overtime law, but may be covered under the federal law. Some workers who are considered companions under the federal law are exempt from federal overtime law, but not exempt from state overtime law. So you want to make sure that you're keeping an eye on what is the worker doing. And also it makes a difference whether the worker is a live-in employee with respect to hours worked and which overtime rules apply. Under the federal law, a live-in employee that's hired directly by the household is exempt from overtime, but may be, again, subject to state overtime laws. The terminology of who's a direct hire, it's directly hired by the household. So is it the person who's the recipient of the care or a family member? I also would think that a direct hire would be also if you're a fiduciary or in some kind of a trust relationship and you're doing the hiring. You may be considered a direct hire for purposes of some of these laws. Next slide, please. So it also matters where the work is performed. There are two sources of law in California that govern working conditions. One is the California Labor Code, which has provisions for overtime, meal and rest break, business expenses, sick leave. There's a whole other host of laws that are in there. And also the wage orders. These are regulations, as Rob said, that are given statutory force. And there are 17 wage orders. If the work is performed in the private household, wage order 15 is going to apply. It's the household occupation wage order, as well as the domestic worker bill of rights, which is codified in the labor code, section 1450 et sec. My office helped to pass that bill. And so we're really proud of the expansion of rights for domestic workers in this arena. If the work is performed in a facility, such as a hospital, board and care homes, residential care facilities, they're called lots of different things, wage order 5 is going to apply. There are different overtime rules that apply depending on which wage order that applies in the state. And then you also want to take a look at the federal law to see if there's any applicability. Generally, the state law provides greater protection than the federal law, but if a worker is exempt under state law, you do want to see if the federal law is applicable in that situation. In addition, you don't want to forget that many municipalities and counties like San Francisco and Los Angeles have passed a higher minimum wage and other labor protections that may apply. So just for example, if a caregiver works in San Francisco, they have to be paid the minimum wage of $16.32 an hour, as opposed to the state minimum wage of $13 an hour. So you do want to make sure that you're not making kind of inadvertent errors about what the applicable law is. I'll turn it over to Rob on the issue of one of the most litigated areas in this arena.
Yeah, Hina, before we talk, I have a question for you because I remember the great work you were doing to get the Domestic Workers Bill of Rights passed. So it's clear to me, okay, if it's in the household owner's house, then wage order 15 is going to apply. If it's in a facility, wage order 5 applies. I've had a few situations where the care recipient moves in to live at the caregiver's home. And so, and I don't know that there is a good answer. And the reason the question it's difficult is wage order 15 applies when you're to working about the home and you're employed by the household owner. Well, now I'm not employed by the household owner. I'm the household owner's employee. Do you think that, which wage order would you think? I think 15 would still apply, but I don't know that a strict interpretation would agree with me.
Yeah, no, I agree. I mean, I think that there are some strange wordings in wage order 15 as to what exactly, does it only apply if it's a direct hire? But there is, the definition of personal attendant that talks about home health agencies. I think it doesn't matter whether the care recipient is living in their own home or a family member's home or in the caregiver's home. I think, and mostly if it's just one person, wage order 15 is going to apply. Now, if the caregiver's home is then converted into a facility, there's 3 or 5 or 6 other residents, then I think you're in wage order 5 territory.
I agree. Good. I just wanted to make sure because I figured I'd ask somebody smarter than me and she could tell me. So thank you. So yeah, you're right. One of the big areas that we get into, and this is really, it is in the caregiver industry, but it's actually all over, is what is considered hours worked. Why is it important? Because an employer has to pay an employee for all hours worked. And each of the wage orders pretty much has an identical definition of hours worked. There can be certain exceptions for certain types of industries, but for the most part, hours worked is the time during which an employee is subject to the control of the employer and includes all time the employee is suffered or permitted to work, whether or not required to do so. So in other words, if I require you to do something, you're subject to my control. If I require you to be somewhere, you're subject to my control. And that was the issue that came up in Mendiola, it was a case dealing with security guards. And the issue is whether or not an employer could deduct for sleep time. This is again to differentiate between federal law. Federal law, there is provisions that allow you to deduct for sleep time if you have an agreement ahead of time. And under wage order 9, there is a specific sleep time provision for ambulance drivers and ambulance attendants. It says if you're an ambulance driver or an ambulance attendant, then you can deduct for sleep time. But there's no state equivalent other than for ambulance drivers that allows for a deduction for sleep time. So in other words, I need you to be at my house. I don't need somebody to actually physically help me 24 hours a day, but I'm a fall risk, I'm a wander risk, whatever the reason is, I need somebody at least at home in case of an emergency. Even if I never call upon you to help me, the fact that I require you to be there means that you are subject to my control. And in the Mendiola case, they were security guards working at construction sites. And so they had a building that the security guards could stay at. They'd go there at 6 p.m. They'd do their walk around, everything gets shut up. Then by 10 o'clock at night, they're able to freely do what they want, but they had to stay on the premises. And in that case, the employer said, look, if you need to leave for some reason, that's not a problem. You just have to give us a call. And if we don't send somebody to you within a short period of time, then we will pay you for that time. But if we send somebody to you, then you're free to go. And the employer argued, hey, you're not subject to our control. You've got internet, you can eat, you can cook, you can do whatever you want. You just have to stay on the premises, or if you're going to leave, you have to let us know. What was interesting is actually the labor commissioner originally, when they looked at that issue, they had gotten an opinion, and the labor commissioner said, no, you can't do that. But then later on said, yes, you could. And I think even the Department of Labor, which is federal, agreed that they could do that. The California Supreme Court did not agree, even though the labor commissioner originally said they couldn't, then said they could. The California Supreme Court said, look, the wage order is very clear. You have to pay for all hours worked. And if you are requiring that person to be there, you are exercising control. So you have to pay for that time. And there is no separate sleep time deduction for in that time. It was the security guards. Same thing applies to the caregivers. So in a 2-year span, for those of you who are keeping track, there's a pretty big change or shift in the caregiver laws. Before 2014, caregivers generally didn't get overtime or were not entitled to overtime. Then 2014 came and they're entitled to get overtime. Then 2015, the Supreme Court confirms that also you have to pay them for all 24 hours a day. And that's when people saw between those two moves, the cost of home care doubled. Pretty much almost not quite overnight. Well, kind of overnight from December 31st, 2013 to January 1, 2014, it went up significantly because they got overtime. But then when people realized they couldn't deduct for sleep time, it went up even higher. And now care agencies stopped providing 24-hour care, at least no single caregiver usually for 24 hours. You can still kind of get it, but it's harder because it's so expensive, because essentially you're paying for 9 regular hours and then 15 overtime hours every single day. So it can get very expensive very quickly. There are some situations where you can allow somebody to stand. I oftentimes come into a case, a trustee or a conservator calls me and say, I just took over this case and they've had this caregiver who's been living on the premises for 3 years. They've been paying her under the table. Well, they haven't been paying, they've just been paying a weekly wage. And what do we do? Well, one of the first things we got to figure out is why are they staying there? Because are situations where I live 30 minutes away and it's just more convenient for me to stay at your house. So I'm going to stay there, but that's for my convenience as the employee, not your convenience as the employer. I think that's rare. And you have to be it has to be very clear that the employee is free to leave the premises. It can't be a little nod in the wink of, hey, I don't really need you after 10 o'clock, but if you stay and you help us out, that's great. No, the person, the employee has to be free from control and they need to be able to leave. So if you've got care plans or other situations, medical situations where the person cannot be left alone, you're looking at paying for somebody throughout that whole time. So that's a big issue that comes up quite frequently. And it's an area of a lot of dispute is which hours will work, not just for caregivers, but in employment laws in general. Hannah, you want to talk a little bit about the hours worked in facilities?
Yeah, so one thing is that there is a difference in what happens at a facility. So at a board and care home or residential care facilities, because different laws apply to the facility. So while Wage Order 15 doesn't have any specific sleep exclusion language, so in the private home, if you're controlling the worker as a live-in or as a 24-hour shift worker, you're going to have to pay for all hours worked. In the facility, it's a different wage order, and it also incorporates, to complicate life, it also incorporates a portion of the federal regulation with respect to hours worked. So the federal law does recognize that a live-in or a 24-hour shift worker is not actively engaged in work at all times. Oftentimes a worker is waiting, and there's a checklist for how facilities should determine what is compensable hours work. So what we're finding is that a lot of times in facilities, one of the major contributing factor to litigation in facility is hours worked and non-compliance with these checklists. And how they pay their workers. Oftentimes the worker in a facility is hired as a live-in employee or is scheduled for 24-hour shifts. They're often being paid a flat daily or monthly rate that doesn't account for all hours worked. And that's the bulk of what we do in terms of representation and in terms of litigation. So there is a checklist, and there are, under certain circumstances, things that can be deducted, such as sleep and meal deductions, as well as whenever the employee is completely free from the employer's control and able to leave the premises. So you can have a live-in employee at a facility who has a pretty schedule and clear instructions of when they are free to leave the premises, when they are not on call, and you can enter into a reasonable agreement. For most of you, the reason it's important to take a look at the facility structure is that, the way that they structure the care and the hours for the caregivers is going to actually impact the quality of care that your recipient is getting. We were involved very actively both in the Domestic Worker Bill of Rights as well as in Mendiola. I argued in the Supreme Court on that case, and there's a reason for why these particular laws are being passed, which is that a worker that is working 24 hours or a full live-in shift and is not being properly compensated is gonna, well, one is that the reason that maximum hour laws exist in California and in the federal system is to discourage people to working long hours and to really discourage overtime pay, because a worker is fatigued when they're on call 24 hours. And sometimes in facility cases that we do, we see a worker who has not had a break for 7 days and is on a 24-hour round the clock shift. And so it does lead to fatigue. Many of these hours worked restrictions and requirements are really to take into account the workers' health and safety, which in turn, I think, impacts the quality of care that the recipients are receiving. There are a lot of technicalities in a facility. What you want to do is inquire. If you're placing someone in a facility, you do want to inquire about staffing, the number of caregivers per shift, and whether they have a dedicated night caregiving staff, and what the what the general requirements are for workers to get breaks, because you do want to make sure that I do think that those things are hand in hand. When you concerned about workers' rights, it's really going to improve the quality of care, because you're going to have a worker who's rested and refreshed to do a good job.
And just to piggyback on that, as an employment attorney, obviously I'm concerned with paying people correctly and make sure. And that's a big reason. Hey, we want to limit our overtime. We need to save some money. But there's these other factors. And I understand people like to have the same caregiver. They like the continuity of care. That makes a lot of sense. But when you have a single caregiver working 24 hours a day, 7 days a week, even if 12 hours of the day, they get to read a book and be on the internet, it is draining. It is tiring. And nobody can maintain that for long. So the quality of care is going to go down. And I think the risk of elder abuse increases. By having multiple caregivers in there, multiple hands in there, you reduce the chance that any one person's going to be abusing the elder without it going to that. So I'm always a big fan of more caregivers, the better. And we'll talk about that. So a little bit about what is the right way to pay. This is the other. So sleep time is a big issue that I deal with. This is the other. And this was a big shot. And a big shock to everybody. I told them how to pay. You always got to pay an hourly rate. Do not ever pay a daily rate, a weekly rate, a monthly rate, or a shift rate. Caregivers they're entitled to overtime. Even if you have a signed agreement translated into 15 languages, signed in blood that says, we're going to pay you for 9 hours at this rate and 10 hours at this rate, at this overtime rate. And so we're just going to combine it all into an hour, a daily or a weekly rate. That is invalid. You have to pay hourly. You have to you got to keep track of all the hours worked so that you can pay correctly. You can pay different rates for different types of work. It does get a little complicated, but there are sometimes it's, hey, if you're working the day shift, I'm going to pay you $20 an hour between 8 a.m. and 8 p.m. But if you work the night shift when you're sleeping, I'm going to pay you minimum wage. When you have a single worker working multiple pay, getting different rates during the same payday or same work day or work week, it does change the calculations a little bit of how much you pay for overtime, but it is something you can do and can be a way to save some of save some money. Always make sure that we have to know when do we have to pay overtime versus regular hours versus overtime, in some cases double time. Domestic workers, personal attendants or caregivers as we call them, personal attendants working in the home don't get double time. They get overtime after 9 hours in a day or 45 regular hours in a week. If they're in a facility or if they're not a personal attendant, then they usually are going to get overtime after 8 hours in a day, 40 hours a week, and they get double time after 12 hours in a day. And then there's also special rules for if somebody works 7 consecutive work days in a row in the same work week, where they get overtime for the first 8 hours and 12 for the overtime after 12 overtime after 8 hours on the 7th consecutive day. Sorry. So the idea is you want to make sure you know what those rules are going in. The employees should be recording not just the total hours. They should be recording their start time and their stop time. You as the employer are required to have those records, and it's really the only way we can make sure that we're paying correctly. I think that wage records or time records that always say the same exact starting time and ending time are problematic because nobody ever starts at the same time and ends at the same time. There's slight differences. I like it when there's minute differences in 8:05 versus 7:55. That's always better. And then also we want to track meal and rest breaks. Now, technically, well, arguably, I should say, personal attendants may be exempt from rest and meal break obligations. Under the wage order 15, they're exempt. But there's a separate labor code section that says you have to give rest and meal breaks. And there's an argument that they are entitled to. Unlike in a facility, there is no provision that allows them to take a rest break and still have to remain on the premises. I typically do recommend explaining to the employee, preferably in writing, hey, you have the right to take a meal break, but because of the nature of the services, we may need you to have what's called an on-duty meal. An on-duty meal means I'm going to pay you for it, but because of the nature of the services, you can't just leave. You certainly want to have that provision in there if that's the situation, and that can at least help eliminate some of the penalties that can apply if you don't pay somebody correctly for resting meal breaks. So keeping track of the hours, again, if they are going to take their meal breaks and they want to log out, log back in, those simple steps eliminates 90% of the lawsuits that I see in the caregiver industry. I do want to mention real quick, because I mentioned it's harder to get 24-hour care through an agency. What I meant to say is it's harder to get a single caregiver that's going to be there 24 hours a day. They will provide 24-hour care. You're just going to have 2 or sometimes 3 different caregivers throughout the day, which technically I think while it may not be ideal for continuity of care, sometimes it is certainly the better practice from an employment law perspective. You can make certain deductions from your minimum wage obligations. And I know this is extremely small, so you can't really see it that well, but you can make certain deductions for room and board. I will tell you that the amount that you can deduct is usually so small that if you're at the point that you're having to make those deductions in order to keep paying this, in-home care is probably not for you. I think if you get breakfast, lunch, and dinner, it's, what is that? It's about less than $20 if you give them breakfast, lunch, and dinner. If they have an apartment to themselves, it's less than $800 a month. If they have their own room to themselves, it's $65 a week. That is the maximum you can deduct, and you have to have that in writing. We get this a lot where somebody comes in, well, yeah, sure, I owe this person $250,000 in overtime, but hey, they got to live rent-free. Well, unless you had an agreement, it doesn't matter. And you can't deduct more than what it says there. And then you also have to consider, if I'm going to give you room and board, is that part of your overtime? When I pay overtime, I have to pay you time and a half on your regular hours worked. And if I'm giving you room and board that's worth $1,000 per month, I may have to calculate that into the room and board. I may have to pay taxes on that. There are some other solutions that you can do. One is to have a separate tenancy agreement. Like if I don't need you to be here 24/7, but you want to stay here because you don't have another place to live, I may want to have a lease agreement where I'm renting you a room and I have an employment agreement. But those are 2 separate transactions. You're paying me rent, I'm paying you wages. The downside of that is you're not deducting it, so you're still paying taxes. You're having taxes withheld. The employee's paying tax on their full wages, and you are probably having to pay taxes on the rental income. The other thing you have to be cautious whenever you let somebody spend the night is, or on a regular basis or live there, are you creating an unintentional tenant? You may now be required to provide 30 days notice or 60 days notice, or during a time of COVID, you can't kick people out. You know, they put a moratorium on kicking people out of the homes, even if they're not paying rent. So you may be stuck with somebody living in your house, even though they're no longer employed by you. So those are things to consider. There are ways, I think, to deal with those, as long as, again, it's being clear up at the beginning and up front of, we're going to allow you to stay here as a guest, but you have no right to tenancy. We'll have to see how those actually get played out.
Before we go on to workplace injuries, I wanted to just add on to the record keeping. You know, there are some exemptions for personal attendants and for household domestic service employers around the types of records that are kept. But because you do have obligations to pay overtime and there are sick leave, which we'll talk about in a minute, I second Rob's recommendation to keep accurate records. For personal attendants, remember there is this 80-20 kind of percentage of what are they doing with their time. If you have a caregiver that is doing household work, they're doing some kind of housekeeping, laundry, cleaning, you want to you want to figure out how much of their time they're spending on doing that. And I would recommend that you track that. It is a week by week inquiry, so you do need to track it per week, what the percentage of time or the exact amount of time they're doing on housekeeping. Because if they're no longer a personal attendant, or if you're so close to that edge, you might be bumped into a much higher overtime world, which kicks in double time. So you really do want to be careful about that. In terms of workplace injuries, most domestic workers who work in the home are entitled to workers' compensation coverage. There's only certain exceptions. If a worker worked at least 52 hours for an employer within a 90-day period before the injury and earned at least $100 within the 90-day period, they're going to be entitled to cover it. Workers' compensation insurance covers things like medical care and wage loss and temporary and permanent disability payments, among other things that are as a result of the injury. And there are caps on those damages. That's why we have a whole workers' compensation system. If a family owns or rents a home, the California Insurance Code requires that any comprehensive personal liability insurance policy for a home or a rental unit must provide for workers' compensation coverage for residential employees. So you'll want to find out if you are a renter or a owner and have a homeowner's insurance, see if that is a comprehensive liability coverage. And then you'll want to notify your policyholder that you do employ a domestic worker so that could be covered automatically. If a domestic worker is injured on the job and you don't have workers' compensation protection, and this is mostly for those who are hiring in the home, the employers could be sued in court over the injury and be responsible not only for medical expenses, but unlimited civil damages, and that could get quite expensive. If you are using an agency for a private household workers, make sure that agency has workers' compensation coverage. Many agencies misclassify their workers or are truly referral agencies and therefore are not treated as employers under the law. So you don't want to assume, oh, it's an agency, I'm going to assume that that's going to be covered. Because again, there is joint employment liability. And so you want to be careful about that. Next slide. There are also other employer obligations called taxes, especially with respect to private household employers. As we discussed at the beginning of this webinar, most household workers will be considered employees and not independent contractors. So if a family directly hires a worker, they're going to need to determine if they have tax obligations. I provided you kind of the thresholds for when California requires withholdings, but the federal system also has some requirements. So if you I think if a family pays $2,300 or more in a calendar year to a household employee, they're going to have to withhold for Social Security and Medicare taxes, and $1,000 or more in any calendar quarter is going to trigger unemployment tax obligations. EDD and the IRS have some, I think, fairly easy to follow brochures and handouts on your tax obligations and how to go about doing this. Many times people who don't want to deal with the private household employee tax stuff go through an agency. Just know that the cost differential is quite expensive. An agency is going to probably charge you more for some of these services.
And sorry, I hit the button earlier. I didn't mean to cut you off there. Although we do got about 5 more minutes before we're going to get to the Q&A portion.
That's plenty on taxes.
So I'm going to jump this. Paid sick leave. Basically, every employer in California has to provide paid sick leave. It can differ. There's a couple of different options, whether you do what's called an accrual or a lump sum. And cities have other specific requirements, like San Francisco, Emeryville, Oakland have their own specific requirements as far as how much paid sick leave somebody accrues and how to do that. If you are a larger employer, if you have 26 or more employees, then you also are required to provide, at least currently, supplemental paid sick leave for COVID-related illnesses. I am of the opinion that even if you're not 26 employees or more, you may want to provide that paid sick leave anyways, because I would rather somebody not come in sick. I'd rather, if they need to take the time off, then they need to take the time off. But so bottom line is paid sick leave, yes, it's a requirement. It's not just a good idea. So what are some of our solutions? So this is number one, I would say use an agency whenever possible. Use a care agency if possible, and use a reputable one. Talk to your colleagues. What are their experiences? A lot of agencies right now are having a hard time getting and retaining good workers, or at least not even good workers, just retaining workers. A lot of them are kind of bumping around for various different reasons. So, talk with the people. You want to ask them a couple of questions, very simple questions. Number one, do you use independent contractors or employees? If they say independent contractors, move on. Second, you ask them, do you follow all state, federal, and local laws? If they say no, move on. They're going to say yes, which brings us to question number 3. Are you willing to put that in writing? And they should. I've never had somebody say no. But I have a slightly modified version that says, we're the employer, we comply with all state, federal, and local laws, and if you're ever sued as the employer, we will defend and indemnify you. Because I've had situations where the care agency doesn't pay correctly, and the attorney sues not just the agency, but the care recipient and the trustee because they were controlling the wages. So we want to make sure there's some language in there that can at least help out. There is another option, which is a third-party employer. A third-party employer is the employer of record. It's kind of a little bit of a hybrid. They can be a little bit less expensive than an agency. You get the control over who to hire, but the third-party employer is the employer of record. They take care of making sure the payments are done correctly, the hours are done correctly, and if you're using a good one, they're paying them correctly. You end up being joint employers that way, but many, at least the third-party employer that I'm thinking of that I recommend a lot of people to, their contract by default says, we're the employer. If you're ever sued as the employer, we will defend and indemnify you. So again, it puts the liability over there and gives you a resource. And then if you are going to do it individually, understand the laws. Give me a call, give Hina a call, find out, do some research so that you make sure we're paying correctly. We've already talked about don't deduct for sleep time, pay an hourly rate, keep track of the hours worked. I always want you to be sure to identify your capacity. When you're hiring somebody and you're acting as the trustee or the conservator, make that clear. Look, I'm not hiring you, they're hiring you. I'm just doing my fiduciary obligation to make sure that, things are done. We have our I's dotted and our T's crossed. So you're not signing your name as your name, you're signing your name under power of attorney or as conservator, etc. Doesn't guarantee you won't get sued, but it decreases the chance and it gives you some protection in the probate code of the obligation for, if you're a trustee, for the trust to indemnify you for things that you're doing in that capacity. How many workers, why does that make a difference? Well, the more workers you have, it can help decrease the overtime. We already talked about lowering the risk of elder abuse. Maybe you need somebody else that's going to be in there managing, but the number of employees you have is going to alter certain requirements. So once you get up to 5 employees, the anti-discrimination laws apply. Now, that's not to say if you have less than 5 employees, you should discriminate. You shouldn't, don't discriminate. But those laws do apply, including providing somebody time off for pregnancy leave, and now for medical leaves of absence under the California Family Rights Act, as well as obligating yourself to provide sexual harassment prevention training. Those of you who need to provide sexual harassment prevention training and are looking to do it online but don't want to pay for it, the Department of Fair Employment and Housing has a pretty good sexual harassment prevention training that is free. It's online, so it's not great. It's just a recording, but you get what you pay for. The final thing is, I like to have everything in writing, but Hina, why don't you go ahead and I'll let you take this one.
Yeah, I agree with you. I mean, from an employer, I don't enjoy suing employers. What I want is compliance, right? And so we recommend that if you are going to directly hire, that you have it in writing. If you are looking for sample contracts, there's a lot of them, but Hand in Hand, which is the Domestic Employer Network, they work with domestic employers. They have lots of sample contracts on their website. They're very straightforward and easy. You just plug in your information. Rob, on this slide has some good suggested terms. One thing is that if you're the caregiver that you're hiring is not, their primary language is not English, I would recommend having the contract translated in their primary language. You don't want the worker to say, I didn't understand what I was signing. That is really important. Again, if you're hiring through an agency, I want to reiterate all of what Rob suggested. You want to make sure that you look at that contract, that you have things in writing, and you do all, and I think you have a right to ask, not only are you complying with state and federal laws, but you can ask, I think, as a consumer, what is the caregiver getting paid? What's the schedule? What's the turnover like? What's the term of cancellation if I'm unhappy with the agency? And then the same thing with the facility. The facility will mostly have a service agreement with you, but it's important to find out what is the minimum length of contract, what services are provided for their monthly rate that you're paying given time. And so I really do want to reiterate that, you know, the writing is kind of your best friend. Think through what, if it's a direct hire, and you're directly doing the hiring, think through the duties and the rates of pay, and also the schedule. You know, especially if you have a 24-hour or live-in worker, you want to really delineate what their on-duty and off-duty times are. Let's go ahead and maybe stop at this point, unless, Rob, you have anything additional to add. We can answer some questions. I do, as an introduction to kind of Rob and I, the way we've met and have collaborated is actually on opposing sides. He has been opposing counsel in many of our lawsuits. And one of the things I really enjoy about, even when he's my opposing counsel, is that I enjoy working with someone who understands the law and understands that compliance is the best route forward. Of course, there are mistakes that are made, and we're hoping that, you know, by teaming up, you understand kind of, you know, compliance is the first step. And what we want to do is avoid litigation. Even for us, you know, I think that it's better for workers to work for employers who know the law, who are getting good advice from people like Rob, and are complying with what their rights are. So we'll open it up for questions.
Thank you, Hina and Rob, for that amazing presentation. Caregivers play such an important role in the lives of older adults and their families. So understanding how to be a good employer while also following the law plays a large role in ensuring the growth of the field as 10,000 people a day continue to turn 65. Our audience has many questions, all of which we hope to get answered in our Q&A. We have about 15 minutes set aside, so for anything we don't get answered today, we will follow up with guests after the presentation. As a reminder, if you have any questions, please submit them in the Q&A icon at the bottom of your screen. You're both there. So go ahead and if you want to make sure you can see us all, then you want to make sure you're on speaker view in the top right corner of your screen. So let's go ahead and get to our first question. When hiring in-home care, can a background check be conducted and how should it be done?
Yeah, yes, it can, and it should. In fact, when you go through an agency, they're a home care organization, they actually are required to do a background check. You don't want to do a background check until you at least make an offer of employment. And I think it's good to, you can make it clear that, hey, we're going to be doing background checks, but you can't just do a background check before you decide whether or not to hire somebody, because the EEOC has done some research, a number of places have done research and finding out that making a decision based on a criminal history can have a disparate impact on persons of color, because there's a higher rate of incarceration, warranted or not, and so it can have this and everything. So the law says you can't do a background check until after you've made an offer, a conditional offer of employment. So the offer of employment say, you know, we're making this offer, and I'd have all the terms, but it would say this offer is conditioned on you passing a background check. Now, let's say you do the background check and it comes back that there is something in the past. That shouldn't be an automatic fail, depending on what it is. It may mean you need to get a little bit more information, and there is a process that you can go through. We can say, you know, we've made this decision, and, you know, they can kind of plead their case or say, oh, you've got the wrong person. That person has the same last name as me, or that's my brother. That's my twin brother. He keeps using my identity. I have identical twins, so I'm looking forward to that at some point in time. So yes, you can. And I think it's a good idea.
And I will just say that if you are planning on rescinding that conditional offer, there are some strict procedural steps you have to take in the state. And so you want to take a look at the law before you take back that offer.
Thank you. So I think this touches on something that was already a little covered, but goes a bit further. When using caregivers, does homeowners insurance cover anything that happens in the home, or because if the homeowner is an employer, do they need separate insurance? I think you did touch on that, but also if going through an agency, would the agency then cover it?
Yeah, you definitely want to make sure that the agency has workers' compensation coverage, and kind of what both Rob and I have iterated is make sure that the employee is treating the worker as their employee, so that the employee then can make a claim with the agency's workers' comp coverage. But in some situations, you might be considered a joint employer, and so it's possible that your policy, your homeowner's policy, may get implicated. But the best defense is to make sure first, to have a homeowner's policy that provides comprehensive coverage, because by law, it covers private residential employees. And then if you use an agency, make sure that they're treating them as employees.
No, I do also definitely recommend, if you're having workers come in, to call your carrier and tell them you want the workers' comp rider.
Mm-hmm.
Technically, it's not necessary usually, but there's two reasons. One, that insurance code section that says it covers workers' comp injuries applies if they worked at least 52 hours before they get injured or earned $100, which for
Right.
most caregivers is gonna be about 4 or 5 hours. But still, I've had somebody who is first day slipped on a leaf on the wet stairs and hurt their back. And so it can happen. So it's like $500 or $600 a year. It's cheap enough. Just get the rider. It's easy.
Okay, and then this one was also answered a little bit, but I'm going to ask if you want to add anything to it. And that is, if you are providing housing to the caregiver, could the percent of wages be deducted as rent? So I think you did address that, but is there anything you wanted to add?
Yeah, no, not really. I mean, yes, you can, but it's such a small amount that I've not seen. Once you go through it, I've never seen anybody who really wants to stick with that.
If a person is receiving care, if a person receiving care did not keep good records, what is the best course of action to take to correct it without litigation?
I want to hear what you had to say about that, I know my answer.
I mean, my thing is that if you believe that there has been some non-compliance with the law, figure out what it is as accurately as possible and try to resolve that with the worker, have the worker, pay the worker what you believe is owed in good faith, and have the worker have the opportunity to consult with an attorney if they want, and then to sign an agreement releasing those claims. Manufacturing the records, going back and trying to recreate those records is not going to serve, in my opinion, the employer well. So I would say try to make a best estimate of what you think you owe the worker if there's non-compliance, and then try to resolve it quickly. And then going forward, as soon as you discover it, create a record keeping system that is done accurately.
Well, I say first thing you do is you fire them right away. No, you're saying I agree with that. And I think you will find most times, particularly when the relationship is still good, you can say, look, we may have made some mistakes. We're not sure. Sometimes you can go back and you can sit down with the employee and they can look at their records. They can look at your records and you guys can come up with something that's good enough. It's like, look, I think this is what you're owed. You think that's what you're owed. Can we come to an agreement? If there's an amount that you know is owed, you cannot say, yes, I know I owe you this money. And if you sign this release, I'll pay it. But you can say, look, I know I owe you this money. I'm paying it. On top of that, I'm going to pay this little extra more and let's have a release. Or if there really is a good faith dispute of, look, I don't know what it is. You don't know what it is. Can we come to an agreement? Then there are ways to resolve it. And I would say it's much easier to resolve things while everybody's getting along than after you fired the person because for whatever reason. Or after you get that letter from, caregiverovertime.com or,
Or from my office.
or from Ina's office.
So let's see, I think just tackle this one as best you can here. What's the difference between a live-in aide who is a quote friend versus an employee? And also, what could the attendee do if they think that they suspect exploitation of someone who is acting as a live-in aide?
Yeah, I mean, I've been I don't know if there is much of a difference. Okay, so there are situations, and there's actually a couple of different organizations that are, I think, county supported, that say, hey, you're looking for a place to live. This person's looking for somebody to help provide some care. We're going to match you two up and you guys can do it. I get real nervous about that. I think that anytime I'm expecting you to do work for me, you're my employee. Because again, we go back to that suffer or permit, or controlling the hours, wages, or working conditions, or am I engaging this person to do work? Now, it's one thing if it is legitimately we're roommates and your job is going to be to do the dishes and take out the garbage. My job is to be to do the gardening or whatever it is. I mean, that's not an employer-employee relationship. But once I start having you doing stuff for me, I think it starts getting problematic. And particularly if it's on a regular basis. If it's, hey, can you come over and help me do this real quick? That's one thing if it's a neighbor. And what was the second part of the question?
What could the person attending this webinar do if they suspect exploitation of someone who's a live-in aide?
Well, Adult Protective Services is a great resource to be able to report to them if you have suspected elder abuse. Many of us are mandatory reporters anyway, so if we suspect that there's abuse going on, we have to report that. Hina, did you have other suggestions?
No, I agree. A friend can be an employee. And so if someone's performing work for you on a regular basis, even on an intermediate basis, but it starts to look like that there's an expectation of the work, then they're an employee. There are some exceptions for close family members, like a parent or a spouse. They're not covered. But for the most part, they're going to be an employee and you want to treat it. If you're worried that the live-in aide is being exploited, you can send them to the state agencies. So if you're feeling like, this is like maybe a trafficking situation or there's some other types of exploitation of the worker, you can send the worker to the state agency, the Department of Labor Standards Enforcement.
Or the Women's Employment Rights Center too.
Yeah, you can send them to me too, but I'm not trying to generate more work for myself.
So I know you already mentioned Hand in Hand, and I think they're also a great organization. The question here is, can you point to any sample contracts that someone could use when hiring in-home care privately so they could cover their legal basis?
So I think one of the handouts we provided was my little Caregiver Blue Book. I think. If not, you can email them, they'll email me. But there are certain terms in there that, like, there's a description of the job duties we were talking about before for a personal tenant. There's an at-will statement that I think I have the indemnification language in there for if you're going through an agency. I am not a fan of let's just Google something and grab something, because you don't have really the ability to evaluate that. Nannies.com, I think, might provide some stuff, or Care.com might provide some stuff, but there's going to be all sorts of disclaimers saying, we're not your attorneys, you should talk to your attorney. So really, talk to your attorneys.
Yeah, I mean, if you can afford to hire an attorney, that's great. I think Rob's handout is very helpful, and Hand in Hand actually has suggested contracts, both for nannies and caregivers, on the resource tab of their website. And this is an organization that is really organizing domestic employers, people who are doing direct hires, and educating them about the law and compliance.
Yes, I am a big fan of them as well. So I think, it made me, you said something, I thought of something, but now I'm looking at the questions. So I don't understand this question, Rob, I hope you do. Why do you think Dynamex is wrong?
I will answer.
Do you think it's wrong too? We agree?
No, I do not agree. No, I will let Rob explain that, but most important, I mean, it's a simplified term. I think there are some procedural issues as to how the court came up with this test, but what the whole point is that I will just say on a policy level that misclassification, there's rampant misclassification of workers, especially in the low wage worker industry. And part of what the court is trying to do is curtail those abuses and those kinds of ways to manipulate the existing test. And Dynamics is like 3 factors, and that's all we need to look at to get to it. I'll let Rob explain why he thinks it's wrong, but I wanted to put in my plug that it is not, it's just a simple test, and it creates clarity for both the employee and the employers as to what their legal obligations are.
My answer, so shortly after the Revolutionary War, we passed this thing called the Constitution. No, my concerns are, one, I didn't like the procedural, the fact that they borrowed from Massachusetts. I also think it was an overly simplified situation. I'm not a big fan, first of all, of the courts creating a new law, which is in effect what they did. I know they called it, no, we're just interpreting an existing law, but this is an entirely new test. Factors were similar, but it applied in an entirely new way that applies retroactively because of the way they did it. So I think that we should leave it up to the legislature to pass laws. Unfortunately, we did, and they did. They passed AB 5, which at least has some exceptions. Like one of my problems with the ABC test is because it's overly simplified, and as it applied until AB 5 came into effect, I have my own law office. I'm busy. I can't make this hearing. So I call my person I share office space with, who has her own law firm, her own staff. I say, hey, can you go do this hearing for me? Because I'm busy. And so she goes and does it. Because she is performing work that I'm in the business to perform under the ABC test, she is my employee. I have to have her for workers' comp. I have to pay track of her hours. If I'm paying hourly, she's not exempt from overtime. So it's not great. Same thing with real estate agencies. Now, thankfully, AB 5 corrected some of that, but we've still got glaring problems of, if you like to go to your local community theater, well, you know, all those actors and the stagehands and the musicians, they're now all your employees. I think it's a heavy-handed approach. I'm not a fan of, hey, let's pass a law. Well, hey, you guys are not following the law, so we're going to pass a more strict law. Well, let's go. And this is the same issue I had with the Domestic Workers Bill of Rights. Let's enforce the laws we have. Sorry, that's my bandwagon. I apologize.
No, and I think some of those criticisms are valid, but at least in this industry, in the domestic workers sector, Dynamics and AB 5 doesn't change the reality. These workers are always, there are very rare exceptions when they become independent contracts. They are really employees. And the general, both from agency, those who are hired by the agency or who are directly hired, there is rampant misclassification, and they are often treated as independent contractors. And a large percentage of my litigation load docket is around challenging those misclassification. Because and through misclassification, you have minimum wage violations, overtime, all kinds of other violations that flow from that.
Yeah, and you're 100% correct. They're, even before Dynamics, even before the Domestic Workers Bill of Rights, these workers were never independent contractors. I mean, they were always employees of someone. This is just not the level. This is not the type of work where you would be an independent contractor. Right. So, and I do appreciate that it gives clarity. I really should be, you know, applauding it, because it just is sending so much work my way. It's like California is the gift that keeps on giving for defense lawyers.
So there was a question that said, how does this work with a home care agency? And I'm going to apologize to the person who wrote that, because I think it was probably very relevant on the slide where it was, but now it's not clear what the question is actually asking. So whoever you are out there, if you have a question that you meant to ask about how it worked with the home care agency in the home for 24-hour care, please email it to conference@lashighcap.org and we will get you an answer. It's a little too vague right now.
I know when that came in. Actually, I know what it was. It was on a 24-hour care. If you got a home care agency, and I tried to address it, it was, yes, you can still get 24-hour care, but if you have a single caregiver through a care agency, you're going to be paying a lot more usually they will provide 2 or sometimes 3 caregivers throughout the day that work rotating shifts.
Okay. Thank you. Yeah, we actually recently experienced that. My grandfather, who's 91, broke a hip in June. Still very independent despite his broken hip, but they were looking at what it would be to have 24-hour care. And even then the agency wanted 2 12-hour caregivers with overtime. And my dad was like, that just doesn't make sense. Like, so then the adult children split up some time to, be there at night or whatever. But yeah, it can get very expensive if you have one person there 24 hours. So
Yep.
Thank you both. I'm going to go ahead and start wrapping up here. So a few reminders, both Rob and Hina, thank you. You can turn off your cameras if you'd like. Thank you for your presentation. We also would like to thank our top sponsors at the diamond level. That's Michael Stevens, Probate and Trust Realtor, and at the platinum level, Campbell Green, LLP, Trust and Estate Attorneys. Special thanks to our gold level sponsors, Acuna Regli, LLP, and the Tile Shop. Also special thanks to our silver level sponsors, Anderson, Yazdi, Huang, Minton, and Horn LLP, and Fiduciary Accounting Services LLC, also Holland and Knight LLP, and Professional Fiduciary Association of California's East Bay chapter. At our bronze level, we have 21st Century Care Solutions, ARM Homes, Evans Law Firm, Golden Gate Fiduciary Services, Law Offices of Sonoy Rousseau, Law Offices of Phillips and Phillips, Lifelong Medical Care, Meredith Taylor of IMT Associates, and our special benefactors, Dan Thomas of Office Information Systems and the Office of Supervisor Wilma Chan. Today's presentation and recordings will be available on the LAS website following the conclusion of the series. If you need CEU credits, please look out for the post-event email in your inbox in the next 48 hours with further instructions. We welcome your feedback about the webinar so that we can continue improving the content we provide and improving on your experience. A link will be included in the post-event email. We invite you to sign up for the rest of our webinar series by visiting the LAS website at lashicap.org and going to events. Our next program is How to Motivate Aging Adults to Make a Money Management Plan on Tuesday, September 21st at 12 p.m. For any questions or comments about today's webinar or the program as a whole, you can email us at conference@lashicap.org. Thank you again for joining us today, and we wish you a great rest of your week. Thank you.